We are delighted to have attorney Kim Martin, partner with Harrison LLP, with us today. Ms. Martin's area of expertise includes special needs, estate planning, guardianship, wills, trust, and their related areas. Please, our next speaker is attorney Kim Martin.
Yes, thank you for including me in this lovely transition fair. I am, as you said, Gail, an attorney and a partner at the firm of Harrison LLP in Atlanta. And my entire practice is devoted to special needs work of one kind or another. Okay, now I'm figuring out how to advance. This is a little stuff about me that I will not bore you with because I only have 20 minutes, I think, to talk about this super important subject of guardianship. But I think that my most important credential to be doing the work that I do is that I am a special needs mom. I have a 16-year-old son who has autism. So he, many years ago, inspired me to kind of reinvent my practice and specialize in special needs work. And he's the reason that I'm here today, and he's the reason that I do everything that I do. So before we get started, I have to do my little disclaimer. So I just have to let you know that the purpose of this meeting is entirely educational. And even though I am an attorney, nothing that I say today should be construed as legal advice. I'm not expressing the opinions of any state or federal agency, and nothing that I say today should be relied upon for your own planning. And there is no substitute for a meeting one-on-one with an attorney who understands your particular situation. So having said that, we can get into the guardianship talk. In Georgia, guardianship actually is only a piece of what you can get to take care of your child. Guardianship itself is care of the person. And guardianship is appropriate if you have a child who turns 18 and is therefore legally an adult, unless they're found to be incapacitated. If you have a child who can't make or communicate significant responsible decisions about their own health or safety, then that is when guardianship would be appropriate. Conservatorship is the other side of that guardianship coin, and conservatorship is needed when the proposed ward, that would be your child, has assets and lacks the ability to manage those assets in a way that's safe and responsible. So you can petition for guardianship only if your child doesn't have any assets. You can petition for guardianship and conservatorship. If you do petition for conservatorship, there are certain assets that are probably not going to be subject to conservatorship. And we care about that because conservatorship means that there is a court overseeing the way that you manage your child's assets. So if your child is on SSI, and if there is a representative payee for SSI, which is very likely to happen, then the SSI assets are not subject to conservatorship. And that's because the rep payee stands in those fiduciary shoes. So we don't need a conservator. We already have a rep payee whose job is to manage those assets. If your child is the beneficiary of a trust, assets that are in the trust are not subject to conservatorship. And again, that's because our trustee is a fiduciary. So they already have the responsibility of making sure the assets in that trust get taken care of and get spent appropriately for the child. ABLE accounts, which are relatively new, they've been around for a few years, but they're starting to come up as things that are, assets at issue in guardianship and conservatorship proceedings. And there's no written law on whether ABLE accounts are subject to conservatorship or not. But every judge that I've been in front of has determined that they are not. So as far as we know, in Georgia, funds in an ABLE account are not subject to conservatorship. So quick terminology, when you're talking about the guardianship process, the way that you get guardianship is you petition a court. And there's a form that every probate court has that you can get online, and I'll get to later to the resources, how to find that form online if you decide that you want to do this yourself. But the people who are asking for guardianship are called the petitioners. There are typically 2 petitioners in a petition for guardianship, because if you only have 1 petitioner, you have to have an affidavit from a doctor within 30 days of the filing of the petition. And that's a pain and it's burdensome. So the easier thing to do is to have 2 petitioners. Then we have the proposed guardian and or the proposed conservator. So the petitioners don't have to both ask to be named as guardian and conservator. Sometimes parents do want to be co-guardians or co-conservators, but you can have 2 petitioners and only 1 proposed guardian or conservator. The proposed ward is your child. That's the person that we are asking a court to find to be incapacitated. And when your child goes through this process, technically it's an adversarial process. Even if everybody's really on the same page, even if your child really wants you to be his guardian because he wants you to be able to help take care of him. But the court will appoint an attorney to represent your child's interests. So the child will have a court-appointed attorney who will speak on behalf of the child at the hearing. So what happens when we pursue guardianship? Assuming that we're successful, there are certain rights that your child will no longer have if they're found to be incapacitated. So the removal of these rights is intended to be for your child's protection. So for example, your child will no longer have the right to marry, because we don't want some unscrupulous person to come along and marry your child so that they can become the rep payee on their SSI, or, put them to work and take their money, or, any other sort of thing that we wouldn't want to have happen. So you lose the right to marry if you're under guardianship. You no longer have the legal right to enter into a contract, which means if there is a lease to be signed or, a purchase to be made, all of those things are contracts. Your guardian can enter into a contract on your behalf. But if you are under guardianship, you can no longer sign and be bound by a contract. You no longer have the right to decide where you're going to live. Your guardian decides that. So that doesn't mean that you can tell your child you're going to live here and then chain him to the bed. You can decide where your child lives if he's under guardianship, but you can't physically restrain him and force him to stay there. The right to consent to medical treatment is removed if you're under guardianship. But again, that doesn't mean you can force medication down your child's throat. Your child always retains the right to refuse to take particular medications. So as guardian, you would have the legal right to get things like medical test results for your child. And to say, if we're looking at course of treatment A and course of treatment B, you can choose, we're going to go with course of treatment B, but you cannot physically force your child to take medications unless he's in danger of hurting himself or somebody else. And the last right that's withdrawn is the right to revoke a revocable trust. That usually applies to older people who, have capacity for most of their lives and then develop dementia or some other incapacity. Your child probably doesn't have a revocable trust, so that's probably not an issue. Your child does retain certain rights when they're under guardianship. So as I said, they can always refuse medical treatment. They can always say, I'm not going to take this pill. I don't want that shot. We can't remove that right from them unless there's a threat of physical harm that may come to the child or to someone else as a result of refusing the medication. Your child always will retain the right to seek independent legal advice and to contest the guardianship if they feel that they should not be under guardianship. Almost always, the ward retains the right to vote. I have seen that removed maybe twice. So typically they will retain the right to vote. It's not on here, but they also retain the right to drive if they can pass the driving test. So if your child has a driver's license and is capable of driving, they would not lose their right to drive if they're under guardianship. If they have the capacity to make a will, they have the right to do that. And they always have the right to participate in decisions that concern them to the extent that they can. That's one of the things you're supposed to do as a guardian, is let your child participate in decisions. So a lot of people come to me and say, we'd really rather not go as far as guardianship. We really want to just have our child sign a power of attorney. And that's something that you can do. It's not always a great idea, but in order to sign a valid power of attorney, your child has to be over age 18. They have to have the capacity to understand what they're signing. So you can't complete a power of attorney, put it in front of your child and say, sign here, and have that be a valid power of attorney. They have to independently choose to sign that power of attorney. It has to be in writing, and in Georgia, it has to be witnessed and notarized. The thing that concerns me about having a child sign a power of attorney and thinking, well, now we don't need guardianship, we have power of attorney, is it doesn't take any rights away from your child. So your child could sign a power of attorney and say, it's okay for my mom to manage my assets, but that doesn't mean that your child can't also manage his assets. That doesn't mean that he can't go to an ATM, take out all of his money and give it to the nice friend that he met at the bus stop. That doesn't mean that he can't go sign up for the brand new iPhone, whatever number it is that we're on now with the 2-year contract, and commit himself to having to pay for that contract. You can't undo that if you're an agent under a power of attorney. Also, a power of attorney can be revoked. So if your child chooses not to have you be his agent anymore and wants to let someone else be his agent, he has the power to do that. Banks hate powers of attorney. They are supposed to be presumptively valid if you sign a statutory form power of attorney, but banks want to know that the power of attorney is valid. So they're going to want to see some evidence that your child had the capacity to sign that power of attorney before they're going to let you act as the agent. And the thing that really worries me about powers of attorney is that they can be evidence that you believe your child has capacity to make his own decisions, because if he doesn't have capacity, he can't sign a power of attorney that's binding. So it worries me when people have their children sign a power of attorney and then 6 months later they petition for guardianship. And one of the questions on that petition is, has the proposed ward ever signed a power of attorney, an advance directive for healthcare, or any other document that names somebody to be their agent? And if the answer is yes, you have to attach a copy to the petition. And the first thing the judge is going to say to you when you go to the hearing is, what are you doing here if you think this person has capacity? If you've got a signed power of attorney that names you as the agent, has something changed between now and the time you had your child sign that power of attorney? So it can be an awkward place to put yourself if you do that, if you think that you are going ultimately to petition for guardianship. So because I have a limited amount of time to talk today, I just came up with some questions that people ask a lot about guardianship. And the questions, I think I'm kind of low on time. Am I low on time? I'm gonna hit the most important ones.
You're fine.
I'm fine. Okay. Tell me if I'm talking too long. So anyone can petition for guardianship as long as they are an interested party. In other words, somebody who knows your child and cares about your child. Most often, I see parents petitioning for guardianship. Sometimes if parents don't petition for guardianship and then they get elderly or they die and there's a sibling who needs to take care of the child, they will come and petition for guardianship because they quickly realize they don't really have the authority to make any decisions or to really take care of their sibling without guardianship. You do not have to be a US citizen to serve as a guardian. That comes up sometimes. People want to know sometimes when the best time is to file for guardianship, and sometimes people get panic stricken and say, oh no, my child's almost 18 and I have to have this petition filed before he turns 18. That's not actually true. The best time to file for guardianship over your child is whenever you feel that it's needed. The earliest that you possibly can petition for guardianship is 6 months before your child's 18th birthday. But if your child turns 18 and they are not under guardianship, they are not going to turn into a pillar of salt. You can petition when they're 25, you can petition when they're 30. I have done a petition for guardianship for a woman who was intellectually disabled her whole life, and we didn't petition for guardianship until she was 68. So there is no deadline, but the earliest you can do it is 6 months before the child's 18th birthday. What happens when you are no longer able to serve as your child's guardian? The guardianship doesn't just evaporate in a puff of smoke because you can't do this job anymore. So once your child is found to be incapacitated, unless that decision is reversed by going back to court and asking a judge to undo the guardianship, there is always going to be a need for a guardian. So one of the things that you should do in conjunction with your petition for guardianship is take a look at your estate planning documents, if you have any, and if you don't, then you should have some, but your will can nominate a successor guardian. So you should nominate somebody in your will to be a successor guardian. If that doesn't happen, your child still needs a guardian, and someone can go to court if you're not able to serve anymore and petition to become the successor guardian. If you become your child's guardian, that does not mean that you're financially liable for his care and support for the rest of his life. You can, do the best you can to manage his benefits. Assuming that you're his conservator, you can manage any assets he may have that are subject to conservatorship. But if there's not enough money to take care of your child, of course, most of us are going to take care of our child anyway, to the extent that we're able to, but you're not legally required to support your child financially if you are your child's guardian. Guardianship is not a get out of jail free card. So if your child commits a crime, they can still be arrested, they can still go to trial, they can still be convicted, they can still be jailed. The good news is if your child is under guardianship and the police are made aware of that, then very often they'll be treated differently. So, if they are, let's say, like my own child, if he gets nervous and freaked out and somebody yells at him to stop moving and put his hands on his head, I promise you he is going to just collapse in a puddle because he won't know what to do. If the police understand this kid is not on drugs, he has autism, you're going to get treated differently, and the consequences of doing something like not listening to a police officer will be different. And if your child does get arrested and there's a hearing, the court will understand this person lacks capacity, and they will view that situation differently. Also, if your child is under guardianship, and if all of this stuff happens, if he gets arrested, if there's a hearing, if you're a guardian, you have a right to notice of that hearing, and you have a right to speak on your child's behalf at the hearing. If all of those things happen and your child is not under guardianship, you don't have a right to say a word at the hearing. The court will not listen to you. So it'll be your child and his court-appointed attorney. Some people worry that they are legally responsible for what their child does if they become the child's guardian. You're not. So if your child does commit a crime, you cannot be charged with a crime. You are legally responsible for what you do. So for example, in the state of Georgia, it's illegal for an incapacitated person to possess a firearm. If you give your child a firearm and he shoots somebody with it, you are legally liable for providing a firearm to an incapacitated person. Some people worry that guardianship is forever, and it can be forever, but if your child improves and regains the capacity to make his own decisions at some point in his life, you can go to court and you can petition the court to undo the guardianship. It's unusual, but I've done it a couple times. It can be done. You do not need permission from a teacher or a therapist or anybody else to seek guardianship. I have had people come to me and say, well, we can't get guardianship because my son's therapist won't sign off on it. Nobody has to sign off on it. The only person who decides whether your child needs guardianship or not is the judge in the probate court of the county where your child lives. You do not have to have guardianship in place to apply for SSI. Coincidentally, those things typically both tend to happen at age 18, but they have nothing to do with each other. So your child can apply for SSI without being under guardianship. And we already talked about the fact that you can't force your child to take medication if he doesn't want to, even if he's under guardianship. In some states, there is sort of a partial guardianship that can be in effect. Georgia does not have partial guardianship. We have guardianship and we have not guardianship. That's it. There is nothing in between. A previous speaker mentioned supported decision-making. Legally, supported decision-making in Georgia is nothing. It has no legal weight or existence whatsoever. So I love the idea of supported decision-making. And for those of you who aren't familiar with what that is, it's when you collect a group of people to advise your child and help him to make decisions himself. And I think that's wonderful, but supported decision-making by itself doesn't remove any rights or powers from the child, which means the child can listen to the supported decision-making group, or he can choose to ignore whatever they say. It doesn't convey any powers to act on behalf of the child. So if you are looking into supported decision-making, I personally like to see it used in tandem with guardianship if you feel that guardianship is appropriate. How am I doing on time?
You're still good.
Okay. So a quick little comment on guardianship. In the lovely days of COVID, when everything is dangerous and nobody should be anywhere in person with anybody else, that has really had a dramatic change in how guardianships are processed in the state of Georgia, especially with regard to specific things. The first thing is the evaluation. So if you petition for guardianship over your child, part of the procedure before the hearing is that the court will appoint an evaluator to meet with your child and write a report saying, here's what I think. Either I think this person does lack capacity and should have a guardian, or I don't. So those evaluations used to happen in person. These days, they're almost always a Zoom call. Or in the early days of COVID, when we hadn't figured everything out yet, there were evaluators who would go to the child's house and they would stand in the front yard and the child would stand in the doorway and they would talk across the yard. So these days, though, evaluators are much more comfortable with doing an evaluation over Zoom. So that is very possibly what will happen during the evaluation. The hearing itself is when the court has received the evaluator's report, the court-appointed attorney has been named, the child has been served with notice that this is all taking place, and those used to happen in person in the probate court. I haven't been to an in-person hearing in almost 2 years now, and a lot of the probate courts are doing so well with the Zoom hearings that they've just decided to make it permanent. So it's very likely, at least for the foreseeable future, that if you petition for guardianship and you have the hearing, it will be a Zoom hearing. And then finally, the oath, when you are named as guardian and conservator, you will have to take an oath. So you'll raise your right hand and swear to do all the things you're supposed to do. The court for a while was having people come to the probate court in person and be sworn in, but they've also gotten more relaxed about using Zoom for that. So these days, most of the time, most judges will swear you in over Zoom. So if you want to find out more about the process of petitioning for guardianship, you don't need an attorney to do this. I mean, you certainly can hire one. I do lots of them, but if you want to do it yourself, the place to look is the website for the probate courts for the state of Georgia. So that's gaprobate.gov. Every county has a different probate court. So just click on the DeKalb County link, and then there should be one of the other links you can click on will say forms. Click on forms, and you can look at the petition that you have to use. And the probate court also does have information about how to petition for guardianship if you're interested in finding out more about that. So that's everything that I have. Thank you so much for letting me talk today, and I hope this was helpful.
This was very helpful. Thank you so very much. And remember, you will have an opportunity to ask questions when we go to our breakout sessions.